Hey, Ultra Legal Warriors, let me tell you something. It's probably not hearsay. It's hearsay. No, what they said is hearsay. They're relying on hearsay. Hearsay has a very specific definition, and most of the time when you're saying it's hearsay, it's not. If you're interested in the state of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, I'm filming this on a Friday. It's late Friday. I think we're going to put this out on a Tuesday. And as always, I'm like, what am I going to talk about? And I was thinking about, what did I hear this week? What did I hear on the phone? I had so many people call up and say, they're just relying on hearsay. You know, they can't rely on that. That's hearsay. Oh, that person who filed that order against me, that's all hearsay. And almost always when someone's complaining about something being hearsay, it simply isn't hearsay. What is hearsay? Well, in many types of court proceedings, the rules of evidence apply. And there's a rule of evidence that basically says hearsay is not admissible unless there's certain exceptions, and certain types of hearsay are admissible. And let's just start with what the definition of hearsay is. Think about hearsay as an out-of-court statement that is now being repeated in court, offered to prove the truth of the matter actually asserted in the statement that was made outside of court. So a classic hearsay example could be, let's say they were trying to prove that the car was speeding, and they bring in an officer to testify, and the officer says, I didn't see the car speeding, but I talked to this neighbor down the street who said they told me the car was speeding. So the prosecutor might ask the officer, so what did the neighbor down the street tell you? Well, they told me the car was speeding. Objection, hearsay. Now, I could object to that as hearsay if what the prosecutor is trying to prove with the officer repeating the out-of-court statement is that the car was actually speeding. Now, how would that same situation not be hearsay? Officer, what first brought your attention to the car? Well, the neighbor told me the car was speeding. Objection, hearsay. Well, that's not going to be hearsay because they're not offering that out-of-court statement to actually show the car was speeding. They're offering that out-of-court statement for the effect on the listener, right? In other words, they're not trying to prove the car was speeding. They're simply asking the officer, what brought your attention to the car? Now, they might have to lay another more foundation if the officer actually stopped the car, but just the same statement, the car was speeding, made by the neighbor, and the officer testifies to that in court. In one example, it's classic hearsay. In one example, it is not hearsay. So it's very complicated, and as a layperson, saying stuff is hearsay is pretty dangerous. Even attorneys often get hearsay wrong. Even judges often get hearsay wrong. There's plenty of appellate law based upon what is admissible or not for someone saying something outside of a court that is being told by someone else in court. So what's an absolute exception to the hearsay rule? Where it is admissible, it's an admission by a party opponent. So think in a criminal case, it's the defendant. Anything the defendant says to anyone that's not the wife, unless it's a DV case, or the lawyer or clergy, that type of stuff, is going to be admissible in court as an exception to the hearsay rule. In other words, if there's a trial going on, the Lori Vallow trial is going on right now. I've been watching that on YouTube, and they might have someone on the stand say, well, what did Miss Vallow say about her beliefs? Well, she believes she's a translated being. So the prosecutor can actually use that statement because it's the defendant telling that to somebody. So they can actually use that to actually try to show that she believes she's a translated being, whatever that means. So anything that you say as a suspect to anybody that's not a protected relationship can be used against you, right? And will be used against you. And you're not going to be able to object to say, hey, you can't bring that person in to court to say what I said because that's something I said out of court. Therefore, it's hearsay. No, the rules say, guess what? Rules work against defendants. What a surprise. They say that can be admitted into evidence. What are some other things that can be admitted into evidence as exceptions to the hearsay rule. Well, let's imagine that it's an arson trial or something, and they're trying to prove that something burned down. Well, they could bring in somebody to say, hey, I heard someone scream, it's on fire, to prove it was on fire, because there's an idea that for an excited utterance or a present sense impression, two different exceptions, that for an excited utterance, you're laboring under the excitement of an event. The fire was so exciting that it's impossible to make it up and lie. I mean, that's obviously not true, but that's the theory of the evidence rules. That then could come in because the person who saw the fire is so excited they couldn't be lying about that. That might also come in under present sense impression. If you're presently describing something you're seeing, like on a 911 call or something like that, there's a thought that that person can't be possibly lying. They're seeing it presently. I mean, it's totally, bizarre that that's how the rules came into place. But remember, these rules were put into place long ago, right? Long before cell phones, things like that. These are some exceptions, again, to the hearsay rule. And I'm not going to go through all the evidence rules, but you can do it to prove lack of absence of mistake, intent, all types of things can be used for letting these out-of-court statements in. So if you're out there and there's some evidence against you and people are saying bad stuff about you, don't think you're just okay. Don't think because people are talking about you outside of the court that stuff isn't necessarily going to be able to be used against you in court, right? Because it probably can. There's very few things that are actually hearsay because a good prosecutor knows how to ask the question to get the statement in from one of the exceptions. And in reality, they're really trying to get the statement in to prove the truth of the matter asserted in reality. But if you're smart, you can do it in a way where you can make an argument that that's not the purpose and the jury still hears it regardless. So when you think about hearsay, remember, don't talk about your case. Don't write about your case. Hearsay rules do also apply to written statements made outside of a court, but there's exceptions to that. There's business records, right? How do you bring in somebody's Amazon purchases, like in the trial going on starting next week in Idaho with the stabbing of the students? How do you do that? Well, there's something called a business records exception. Amazon maintains those records not for the purposes of litigation, the purchase records, but purposes of their own business. Well, automatically that's supposed to be thought to be reliable. The whole purpose of the hearsay rule is to exclude unreliable testimony where the testimony is against the defendant doesn't have the chance to cross-examine the person making the statement outside of court. And so when we can come up with the rules with these ways that the statement might otherwise be reliable, it's sort of they relax that, and now they let it in even if you don't get to cross-examine someone. There are constitutional limits. In Washington State, there's a case called Crawford that can limit some of these things. There could have to be a Crawford hearing about the limits of these exceptions. Those often apply to 911 calls, but I just want you to really be careful and talk to a legal professional and bring it down about 3 notches when we're worried about, it's hearsay, because most of the time it's not actually hearsay as defined under evidence rules. So I hope you found that useful. If so, please like and please subscribe. More people get to see it, more people get the help they need. More importantly, if you got a criminal problem in Washington State, feel free to reach out to my firm. We've been doing this more than 25 years. If we get on board, we'll listen to what happened, we'll identify a way forward. We will be there for you. Thank you.